Having explored the concept of crop rights and how the law distinguishes between agricultural production and real property ownership, we now shift to an equally vital distinction in Arizona real estate law: the difference between unsubdivided land and subdivided lots. This topic lies at the heart of Arizona's land development regulations and directly impacts how properties are marketed, sold, and reported to the Arizona Department of Real Estate, ADRE. Understanding this distinction is fundamental for real estate licensees because it determines the level of disclosure, registration, and consumer protection required under the Arizona Subdivided Lands Act and Unsubdivided Lands Act. Arizona law defines these terms in ARS, paragraph 32 to 2101, which provides the framework for how land is classified when offered for sale or lease. The distinction between subdivided and unsubdivided land hinges primarily on parcel size, intended use, and number of lots created from a single parcel. This classification affects everything from the issuance of public reports to the buyer's right to rescind and the developer's marketing obligations. Under ARS, paragraph 32 210158, subdivided land refers to improved or unimproved land divided into 6 or more lots, parcels, or fractional interests, each less than 36 acres, for sale or lease. This category typically includes residential developments, such as single-family home subdivisions, townhome communities, and platted residential tracts. The purpose of this definition is to ensure consumer protection when smaller parcels, especially those intended for home ownership, are marketed to the public. In contrast, ARS, paragraph 32 210163, defines unsubdivided land as parcels divided into 6 or more lots, parcels, or fractional interests, each 36 acres or more but less than 160 acres in size. This type of land is usually found in rural or agricultural areas and is commonly sold for investment, ranching, or recreational use, rather than residential construction. Because these parcels are larger and less developed, the law assumes that buyers of unsubdivided land are more experienced or sophisticated investors who require a slightly different form of disclosure. The ADRE enforces both the Subdivided Lands Act, ARS, paragraph 32 2181 at SEQ, and the Unsubdivided Lands Act, ARS, paragraph 32 2183 at SEC, ensuring that developers and licensees comply with disclosure requirements before any subdivided or unsubdivided lots can be legally offered for sale. The subdivider must obtain a public report from the commissioner, disclosing material facts about the property. However, the content of the public report varies depending on whether the land is subdivided or unsubdivided. For subdivided land, the report must detail zoning, access, utilities, drainage, flood zones, and restrictions. For unsubdivided land, additional attention is given to water availability, road access, proximity to services, and potential development limitations. For example, a developer planning to sell a 20-acre parcel in Pinal County by dividing it into 10 2-acre home lots would be selling subdivided land because each lot is smaller than 36 acres, and the total number of lots exceeds 6. This developer must submit a notice of intent to subdivide, secure local government approval for the plat, and obtain a public report from ADRA before any sales occur. Conversely, if the developer instead divides the same parcel into 6 40-acre tracts for sale as ranch or recreational property, it would qualify as unsubdivided land. The developer must still obtain a public report, but under the Unsubdivided Lands Act, which emphasizes access, legal descriptions, and off-site improvements rather than utilities or home construction. A critical practical difference between the two lies in buyer rescission rights. Under ARS, paragraph 32 2185 also 1D, purchasers of subdivided land have a 7-calendar-day rescission period after signing the purchase contract if they have received the public report in advance, or a longer period if the public report is delivered after execution. In the case of unsubdivided land, ARS, paragraph 32, 1283, Workis 01E, provides a 6-month rescission right if the purchaser has not inspected the property before signing the contract. This extended period recognizes the complexity and potential remoteness of unsubdivided parcels and provides greater protection for buyers unfamiliar with the property's terrain or accessibility. Arizona courts have consistently upheld these distinctions to ensure compliance and protect consumers. In State ex Relas Corbin v. Pickrell, 1983, the Arizona Supreme Court reinforced the commissioner's authority to require registration and reporting for both subdivided and unsubdivided lands, emphasizing that the state's intent was to prevent fraud and misrepresentation in land sales, especially in rural developments marketed to out-of-state buyers. For licensees, understanding these classifications is not merely academic. It directly affects compliance with AAC R4 28301A, which requires agents to disclose all material facts and ensure all required reports are provided before accepting any earnest money. Listing or selling unsubdivided or subdivided land without a valid public report violates ARS, paragraph 32 to 183, and can result in license suspension or revocation under ARS, paragraph 32 to 153, for improper conduct. Review summary. The key distinction between unsubdivided and subdivided land in Arizona lies in the size of the parcels and intended use. Subdivided land involves parcels smaller than 36 acres, often for residential development, while unsubdivided land includes parcels between 36 and 160 acres, commonly used for agricultural or investment purposes. Both categories require a public report before sale, but the disclosure requirements differ. Subdivided land focuses on residential and infrastructure details, whereas unsubdivided land emphasizes access, utilities, and water availability. Understanding these differences ensures compliance with Arizona's land division statutes and protects both consumers and licensees. Discussion prompts. Why does Arizona law treat subdivided and unsubdivided land differently in terms of disclosure and rescission rights? Answer. Because smaller residential parcels typically involve less experienced buyers who need greater consumer protection, while larger parcels attract more sophisticated investors who require different information. What key factor distinguishes subdivided land from unsubdivided land? Answer. Parcel size. Subdivided land involves lots under 36 acres, while unsubdivided land includes lots between 36 and 160 acres. Why must a developer obtain a public report before selling subdivided or unsubdivided land? Answer. To disclose all material facts about the property and comply with ADRI regulations designed to protect buyers. Closing remarks. Differentiating between subdivided and unsubdivided land is one of the cornerstones of Arizona's land development law. These classifications safeguard consumers while allowing legitimate land development to flourish under clear regulatory guidelines. For brokers and agents, understanding these laws ensures ethical practice, prevents violations, and builds public trust in Arizona's real estate system. Each transaction involving vacant or rural property must be approached with diligence, ensuring that disclosure and registration obligations are fully met.